Hello everyone and welcome to our first HR Law webinar of 2025. Thank you for joining us as we navigate the legal framework of conflicting belief systems and discrimination allegations. An easy topic, not. So before we start, can I just introduce myself for anyone who doesn't know me? I'm Marion Bloodworth. I'm a partner in the team and I joined Fox Williams in October last year, having worked in a number of firms elsewhere in the city and most latterly at Deloitte Legal. I happen to have a particular interest in diversity and discrimination and workplace culture, and that's particularly because a lot of the work I do is in the financial services and professional services sector, whereas any of you joining who are in those sectors will know the regulators in particular have a keen interest in monitoring culture and conduct in the workplace. So a few admin points before I introduce our other speakers. You will have noticed already the webinar is being recorded. It doesn't see you or any of the comments you make, it's all anonymous, but that recording will then be made available to anyone who's registered but unable to join us, as well as those of you who have. Now, we're happy to take questions on the topics under discussion. If you have any questions, please put them in the Q&A box rather than the chat box. We'll aim to cover those in the session at the end once our speakers have finished. And if we don't have time to tackle them all, then please don't worry, we will keep a record of them and we will follow up after the event. So we like to make our webinars topical, and this one is genuinely that. You may be aware that there's a Scottish tribunal at the moment that's currently considering a case regarding the provision of single-sex changing rooms in the NHS and how best to accommodate transgender employees. Across the pond in the US, we're seeing reversals of DE&I policies and programmes and a general increase in the expression of more polarised views, including on social media. And the effects of that are being felt over here. And as Lucy will explain, just yesterday, the Court of Appeal here handed down its decision in one of the cases we want to talk about today. So let's have a look at how we're going to cover all of that on our agenda. If we could move to that slide, please. So today isn't going to be a complete review of every kind of potentially protected belief system. We would need a whole afternoon and then probably some more to do that. But what we wanted to do is remind you of the laws that operate in this space so that you've got these as your frame of reference. Then we'll look at some of the key cases, and then bearing in mind, of course, that you need to manage these situations in the workplace on a day-to-day basis. You're not running tribunals and courts. We'll look at some practical points to consider. So the agenda sets out how we're going to do that. I'm going to start with the overview and the legal framework. Lucy will go on to talk about the case law on the matter, including, as I say, yesterday's decision. And then Nella will spend a bit of time on practical guidance relating to conflicting grievances, overlapping procedures, and how you set the right tone for workplace discussions and some alternatives, in fact, to escalation. We'll then finish with a Q&A session, depending on how much time we have available. And as I said, we will always follow up with you afterwards in any event. So if we can move straight into having a look at our legal background and the legal framework. I think it's true to say that this is very much a situation of having to operate a balancing act. If we have a look at the next slide, this shows you some of the points that we want to make about the underlying principles that apply in the workplace. So individuals at work have the right to hold and express their religion or beliefs, but that is not unqualified. There is a balancing act, as our picture here shows, given that other colleagues also have rights, in particular the right not to be discriminated against or harassed. And if we put that in a practical context, for example, take a manager within the workplace who happens to have gender critical views. So they believe that sex is binary, immutable and biological. And contrast that against the rights of an individual employee who's non-binary, and they have rights to not be treated less favourably. So the consideration that kicks in quite a lot is, at what point do expressions of personal beliefs cross over and become classified as hate speech, racism, homophobic or transphobic? And the rights of individuals to hold and express certain views can result in the discrimination or harassment of others, or indeed, in some cases, discrimination or harassment of the individual themselves having expressed those views. But it doesn't always actually lead to that, and that can be where tensions arise. If an individual holds different views or disagrees with a colleague or their line manager, it doesn't mean that they have necessarily been discriminated against or harassed, and that's going to depend on the facts in each case. And we've seen this play out in a number of different scenarios, and indeed the case law reflects this a little bit as well. So you might have one scenario where employees, as I say, hold different views to other employees, and that can create workplace tensions. You might have employees who object to what they're being asked to do by their employer because that conflicts with their beliefs. And we've seen case law historically, for example, about marriage guidance counsellors who found it difficult to give guidance to same-sex couples because it conflicted with their religious belief. Or in some cases, employees have directly engaged in a way that the employer didn't necessarily support with customers or clients, and they've expressed their views in the course of providing their services. Now, we know, we get this, it's not an easy path to walk for HR advisors or indeed employment law advisors. And understandably, as I say, it's been the subject of much case law, and some of that Lucy's going to come on to discuss in a moment. And even with the best intentions, employers can face disputes if they fail to adequately balance what are seen as the competing rights and issues. And again, that's where Nella's going to come in with her tips around how best to manage this in the workplace. So if we have a look at the next slide, what are the rights of people in the workplace? What are my rights as an individual at work? And we start by looking at the Equality Act 2010, which gives statutory protection. And that clearly states that an individual must not be discriminated against or harassed for having one or more of the protected characteristics under the Equality Act. I'll run through these, but these are the 9 that you'll be familiar with: disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, sex and sexual orientation. And it's really important to note that the Equality Act doesn't give precedence to one protected characteristic over another. There's no trumping of rights, so to speak, no hierarchy. All protected characteristics are equal, and the protections against them are the same, with very few exceptions. So if we have a look at the next slide, just a reminder as to what those rights are. And again, we could hold a seminar on its own simply about the various forms of discrimination that there are. But as a brief reminder of the types of discrimination that an individual may experience in light of the 9 protected characteristics, probably the main ones to draw your attention to are direct discrimination, which is less favourable treatment compared to others because of a protected characteristic; indirect discrimination, which occurs where an employer operates a provision, criterion or practice that on the face of it seems to apply to everybody but disadvantages an individual and a group with a protected characteristic. And the classic examples given there, for example, are around requirements to work either full-time or weekends, which may disadvantage female employees who have childcaring responsibilities. Then we have protection from harassment, and harassment is defined in a couple of ways. It's unwanted conduct which has the purpose or effect of either violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. Or specifically, it's conduct of a sexual nature that has the same purpose or effect, or it's less favourable treatment because of rejection or submissions to sexual harassment. The other strand we often worry about is victimisation, which is where an individual suffers a detriment because they've done something, or it's clear they intend to do it, or they're suspected of doing something, which is classified as a protected act. And that does include claiming that somebody has breached the Equality Act, whether that's a grievance or bringing a claim, for example, in the tribunal. And there are, of course, as I say, other categories, but those are probably the ones that we want to focus on now. So if we look at the next slide, this is the area where a lot of these competing belief situations have arisen. So what is the right to hold a religion or belief? It's, as I say, it's where these beliefs overlap or at worst conflict that we've seen our problems and issues. Now, religion or belief is a protected characteristic under the Equality Act. And whilst most people probably appreciate what a religion is, belief is the one that's led to a lot of case law. And that is as defined as any religious or philosophical belief. And a reference to belief can include, don't forget, a reference to a lack of belief. So atheism is just as valid a belief as, for example, Judaism. So we've seen quite a lot of case law on this, and a protected belief can be something that's capable of protection even where it's controversial, offensive or unpopular. And the test for determining whether a belief is protected is the one that was laid down in the Granger case, which you might remember. And that did take into account an individual's rights under the European Convention on Human Rights, which I'm going to come to in a minute. And it set out that there are 5 criteria for establishing whether something is capable of being a protected belief. And this is where there has been a lot of case law. So that belief must be genuinely held. It must be a belief and not just an opinion or a viewpoint. It's got to be a belief as to a weighty and substantial aspect of human life and behaviour. It's got to attain a certain level of cogency, seriousness, cohesion and importance. And it's got to be a belief that's worthy of respect in a democratic society, not incompatible with human dignity, and one that doesn't conflict with the fundamental rights of others. And again, we've seen some case law here, particularly where political beliefs were involved, and some of these cases have gone all the way to the European Court of Human Rights. And they've also made clear that a belief mustn't be conflated with an intention to discriminate. So as an employer, it can be genuinely hard to work out where the problem lies in terms of somebody manifesting a belief. And a point that Lucy's going to come on to discuss is the key challenge for employers, because the problem usually is in how a belief is expressed and whether the conduct that the employee commits is related to it. And as I say, I'll leave Lucy to expand on that a little bit more. And then the challenge for an employer when they're being criticised or taken to tribunal by an employee is to establish whether the action they took was because of the protected belief or because of the way in which that belief was manifested. But that test is really important in determining whether the individual has in fact been discriminated against for having that belief. Having just said all that, though, it isn't always straightforward or possible to adequately separate an individual's conduct from the beliefs themselves, where they're so closely tied up. And so if you're familiar with the Forstater case, the claimant there was successful in arguing that the manifestation of her belief, and she has gender critical beliefs, and she said that was indissociable from the belief itself, because when she wrote about it, when she communicated about that, that was no more than an assertion of her core protected belief, which couldn't be objected to, even though it was accepted that it might cause offence to others. And you might also remember the case of Awada. And when we first started hearing about these cases, this is a good sort of 15, 16 years ago, quite a lot of them were about individuals wanting to manifest their religious belief in the context of things like uniform and working practices. And again, that case went all the way to the European Court of Human Rights, and they held that to count as a manifestation under the Convention on Human Rights, there must be a sufficiently close and direct nexus between the act that the employee does and the underlying belief. And again, the recent case that Lucy will talk about talks about that a little bit as well. So I've introduced the European Convention on Human Rights. Let's just have a quick reminder of what an individual's rights are under these, if we could move to the next slide. Human rights are often quoted, as you'll be aware, in cases around expression, freedom of expression and freedom of belief. Now, the UK remains a signatory to this convention despite Brexit, and our Human Rights Act 1998 requires courts and tribunals in England to read and give effect to national statutory provisions in a way which is, so far as possible, compatible with the rights that the convention confer. And so under the convention, individuals have the right to freedom of thought, conscience and religion, and to manifest those. They have the right to freedom of expression, and that's the right to hold and express opinions, as well as to receive and impart ideas to others. And that does include, for example, where those beliefs or the expression of them might be offensive to other people. Individuals have the right to respect for private and family life. But as you would expect in all of those cases, and they all have their own little provisions, those rights aren't absolute, they're not blanket, and they can be qualified in some ways. And that is typically where a degree of restraint is required to be in accordance with a democratic society, in the interest of specified legitimate objects, public safety, the protection of public order, health or morals, and also the protection and the rights and freedoms of others. And it is very important, therefore, to bear in mind that those are not blanket rights. Article 17 prohibits the abuse of any of those rights to engage in any activity aimed at the destruction of them. But again, the EAT had to look at this in the Forstater case and held that only some beliefs, and they have to be very strong beliefs, such as Nazism or totalitarianism, or any belief which espouses violence and hatred in the gravest forms. It's only those kind of beliefs that would fail the test of being worthy of respect, and under Article 17 would fall outside the scope of protection. And as I say, it's not enough that the belief is offensive or shocking to some people, or that it might lead to harassment of others. And the focus shouldn't be on how an individual manifested their belief when determining whether the belief itself was one that was capable of protection. So I appreciate I have just done a little bit of a quick tour of our legislative framework, but it now falls to me to hand over to Lucy, who's going to have a look at a discussion of the case law position as it's shaped by these laws and by the cases that people have brought. So over to you, Lucy.
Thank you so much, Marion. If we could just go to the next slide, please. We're going to look at a case, the Higgs and Farmer School case, which gives some helpful guidance on the proportionality point. And unhelpfully, often these types of cases are very much fact specific, and we have seen some inconsistency in judgments, but we do have some guidance in particular emerging out of this case, which is quite useful in determining some of the key principles. And as Marion mentioned, of course, the Court of Appeal judgment in this case came out just yesterday, so we've had to do some very quick reading and digesting of the judgment. So a brief overview of what happened in the case. The employee worked as a pastoral administrator and work experience manager in a secondary school, and she created a number of Facebook posts which reshared articles relating to relationships education in primary schools. And the articles expressed views which appeared to be gender critical and critical of same-sex marriages and the ways in which children were educated on both of these topics, among other things. And while Mrs. Higgs shared the articles, she didn't specifically endorse all of the views expressed in them, and nor did she comment specifically on their contents, except that she did repeat one suggestion made by one of the articles that children were being brainwashed, and she also made a number of references to the LGBT crowd, which appeared to be quite derogatory. So after someone complained about these posts, Mrs. Higgs was suspended, and after a disciplinary investigation, she was subsequently dismissed from her employment. And she complained that these actions amounted to direct discrimination because of or harassment related to her protected beliefs. And the Employment Tribunal concluded that the measures taken by the school had been due to its concerns that someone reading Mrs. Higgs's posts could reasonably think that she agreed with the homophobic and transphobic views in the article she was sharing, which she firmly denied. And it said that on the basis of that, the reasons for the school's actions was therefore not because of or related to her protected beliefs, but rather a risk that people could think that she agreed with the views in the article. She appealed, and the Employment Appeals Tribunal remitted the case for determination on the basis that it had been found that the Facebook posts were closely linked enough with Mrs. Higgs' actual beliefs that they amounted to a manifestation of those beliefs. So Articles 9 and 10 were engaged. And recognising those fundamental rights, the tribunal would be required to determine, first of all, whether the measures adopted by the school were prescribed by law, and if so, whether those measures that the school had taken were necessary to protect the rights, freedoms, or reputation of others, so the proportionality assessment. And the EAT cautioned against attempts to lay down general guidelines in these types of cases due to their fact specificity, but nonetheless, it did set out 5 basic principles that underpin the approach to be taken when assessing the proportionality, which we'll look at beginning on the next slide. So the first of those principles is that the foundational nature of rights must be recognised. So the freedom to manifest beliefs and to express views relating to those beliefs are essential rights in any democracy, whether or not the belief in question is popular or mainstream, and even if it may be offensive to some people. The second principle, however, is that those rights are qualified, and the manifestation of belief and free expression will be protected, but not where the law permits the limitation or restriction of that manifestation or expression in order to protect other people's rights and freedoms. And whether that limitation or restriction is objectively justified, given the manner of the manifestation or expression, that's not action taken because of the person's beliefs, but is by reason of the objectionable manner in which they're expressed. If we could move to the next slide, please. So the third principle is that whether a limitation or restriction is objectively justified will always be context specific, and different considerations will inevitably arise depending on the nature of the employment and the surrounding circumstances. And the fourth principle is that it will be always necessary to ask the questions identified in the Bank Mellat case. So the first of those questions is whether the objective that the employer is seeking to achieve is sufficiently important to justify the limitation of the right in question. So in this case, whether the objective that the school was trying to achieve in protecting its reputation was important enough to justify the action of dismissing Mrs. Higgs, whether the limitation is rationally connected to that objective, whether a less intrusive limitation might be imposed without undermining the achievement of the objective in question. So in this case, was it possible to still achieve the objective that the school was trying to get to by imposing a less intrusive limitation? So perhaps not going quite so far as to dismiss Mrs. Higgs. And then fourthly, whether balancing the severity of the limitation on the rights of the worker concerned against the importance of the objective, the former outweighs the latter. So kind of balancing the severity of the measure that the school was taking in dismissing Mrs. Higgs with her rights to express and manifest her beliefs. And if we could go to the next slide, please. Finally, the Court of Appeal elaborated on some of the considerations that were likely to be relevant when considering this proportionality assessment. And these are all considerations related to the manner in which the belief is manifested and the sort of content of how they're manifested. So things like the tone of the message that's disseminated, the extent of it, the reach of it, and the likely audience, the extent of the intrusion on the rights of others, and the consequential impact on the employer when running the business, the clarity of whether those views are held by the individual, whether they might be actually linked to the employer, and relatedly, the reputational risk arising out of that. Power imbalances, the nature of the employer's business, and assessment as to whether the limitation is the least intrusive measure which is open to the employer. And if we could move to the next slide, please, we'll look at what the Court of Appeal said. So the Court of Appeal looked at whether the dismissal was objectively justified, which the EAT hadn't opined on. And the Court of Appeal held that it constituted unlawful discrimination. It held that while the school was entitled to object to the posts on the basis that the language was offensive, dismissal was a disproportionate response. The language used was objectionable, but it wasn't grossly offensive, and it was compared to other cases where the language used had been more equivalent to hate speech. The court held that in this case, the language was more akin to derogatory sneers. The court took into consideration the language wasn't the claimant's own. So other than repeating the word brainwashing, she hadn't repeated any of the other content of the articles, and she'd actually made clear during the investigation process that she didn't agree with the rest of it. There was no evidence of damage to the school's reputation, so the school was concerned about future damage to its reputation, but that was more of a hypothetical concern because there was no evidence that its reputation had actually been damaged in the court's view. And there was no risk of readers thinking that the posts reflected the school's views because they were not obviously connected with the school. The Mrs. Higgs had not posted using her married name. She posted using her maiden name, and it wasn't obvious that she worked at the school, and there was no link to the school on her Facebook page. There was no evidence to suggest that Mrs. Higgs's views would influence her work, and so the dismissal was disproportionate. So it's a very useful summary of how the relevant legal tests might apply. In this case, the school wasn't able to show the level of risk or damage to justify a dismissal. And some commentators have already expressed concern about the impact of this judgment and that it could be misunderstood and empower people with strongly held views to express them in an offensive manner and to feel that they won't suffer any consequences. And it remains to be seen how courts will decide some other cases which are currently moving through the courts in which significantly more offence has been caused by comments made. So if we could move to the next slide, please. We're going to look at just a few more cases on this topic. So there are two cases in which employees who expressed gender critical views were marginalised by their employers. And the first of those is Adams and Edinburgh Rape Crisis Centre. So in this case, an employment tribunal held that an employee was discriminated against and constructively dismissed because of her gender critical beliefs. So the claimant, Ms. Adams, believes that biological sex is real, important, immutable, and not to be conflated with gender identity, but she is supportive of trans inclusion. And she believes that survivors of sexual violence should have a choice about their support worker's sex. And she worked for Edinburgh Rape Crisis Centre, which had an occupational requirement of only recruiting women and a policy of supporting women, trans and non-binary people. So a new CEO was appointed who was a trans woman without a gender recognition certificate, and Mrs. Adams became concerned with the centre's approach to gender identity, which differed from her beliefs. And when a service user queried the gender of a colleague who had taken on a male name, Ms. Adams suggested they respond that the colleague was born a woman but now identifies as non-binary. And before any investigation into those comments had taken place, the CEO emailed Ms. Adams's colleagues, advising that she'd humiliated the non-binary colleague, that they would not be working together again, and implying, probably most importantly, that Ms. Adams was transphobic. Ms. Adams' actions were held to be gross misconduct. She raised a grievance about this, and she must not have been actually dismissed for gross misconduct because she resigned and made a claim for constructive dismissal. And the tribunal found that she had been harassed and that the same acts would amount to direct discrimination, and also that the centre had indirectly discriminated against her by treating the manifestations of her gender critical beliefs as a disciplinary matter, and that could not be objectively justified in this case. And I think importantly, the tribunal observed that the CEO believed that gender critical beliefs were inherently hateful and positioned them as transphobic, and that influenced the decision to take disciplinary action before a full investigation had taken place. And that meant that the Rape Crisis Centre had breached the implied term of mutual trust and confidence, and Ms. Adams had been constructively dismissed. And then there's another case, Farmy and Arts Council England, where the actions of the Deputy Chief Executive in emailing All Star, indicating his personal solidarity with trans and non-binary colleagues, had unintentional consequences and led to a gender critical employee feeling harassed. And in that case, as with the Adams case, it was the positioning of gender critical beliefs as inherently hateful and transphobic, which meant that the behaviour crossed the line into harassment. So that's quite a useful principle to draw out of both of those cases. A couple of cases on zero tolerance policies, and this is quite interesting because a number of employers we've observed have applied zero tolerance policies internally with sort of varying degrees of success in engendering good behaviours. And these cases demonstrate that well-meaning employees who follow these policies won't always lead to the best outcomes. And in Jeffries and Apple Retail, an employment tribunal held that Mr. Jeffries had been unfairly dismissed for making a joke to a colleague of Chinese heritage about China's responsibility for the COVID-19 epidemic. The colleague didn't actually take offence at that, and what's more, the tribunal found that similar jokes and banter were commonplace within that team. It was overheard by a manager who also wasn't offended, but believed that it was his responsibility to report the matter, and Mr. Jeffries was dismissed. And the tribunal held that although the matter was investigated and treated as if Apple had a zero tolerance policy on paper, this was not in fact the case from its policies and the way that they were implemented in the workplace and the way that people behaved. That said, a clearly stated zero tolerance policy will also not necessarily allow an employer to dismiss fairly. And in Borg Neal and Lloyd's Banking Group, which is quite an extreme case, Mr. Borg Neal admitted to using the N-word to illustrate an example of unacceptable language in a racial awareness training session, and was subsequently dismissed for breaching the bank's zero tolerance, anti-discrimination and disciplinary policies. However, a tribunal held that he had been unfairly dismissed, and that a zero tolerance policy would not necessarily mean that an employer could fairly dismiss in every case. So I think a couple of examples of how zero tolerance policies should be carefully stated and also carefully applied and considered in each case whether you're reaching an outcome which is fair with all of the circumstances taken into account. And finally, just wanted to touch on the 2024 Thomas case, in which the EAT considered whether an individual's belief in English nationalism, which included explicitly anti-Muslim beliefs, could constitute a protected philosophical belief under Section 10 of the Equality Act. And in this particular case, Article 17 of the ECHR, which Marion mentioned earlier, which prohibits the use of ECHR rights to destroy the protected rights of others, was considered. And on that basis, it was held that the belief was not protected. English nationalism alone would be likely to have been capable of the protection of Section 10, but it was the fact that there was a disdainful and prejudiced focus on Islam to the exclusion of all other religions and belief systems, which meant that the belief was prevented from being a protected belief under Section 10 of the Equality Act. And notably, among the claimants' views were that Muslims should be forcibly deported from the UK. And it was held, in some ways, not surprisingly, that these views are not capable of protection under the European Convention of Human Rights, as they would defend Article 17, which provides that nothing in the Convention may be interpreted as applying for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any rights and freedoms set forth herein, or at their limitation to a greater extent than is provided for in the Convention. So that's a whistle-stop tour through some recent cases. And I'm now going to hand over to Nella to talk about the practical implications of all of this.
Thank you so much, Lucy. So I will now be moving on to talk about some of the practical points for employers to consider when employees raise grievances where there are one or more different beliefs that are not aligned with each other. So I'll be having a look at how to deal with employees disagreeing with other employees. Next slide, please. Briefly, to pick up on what Lucy said on the Higgs case, one of the summary points that the Court of Appeal was keen to stress is that if an employee is dismissed solely for expressing a belief that is protected, that is very likely to be direct discrimination. This is something that employers will need to bear in mind when managing these issues, and one which we can also expect employees to be aware of. The challenge then is in navigating a way through when this does happen. An obvious point, but as we have seen in several cases, workplace policies and rules are ever more important. Really, it's of paramount importance not to circumvent company procedure when it comes to any grievances received or any perceived disciplinary action that might be needed following a grievance or where an informal complaint is raised. Each complaint raised should be dealt with appropriately and separately in turn. Then appropriate consideration should be given to the next steps that might be needed before proceeding with any kind of disciplinary sanction that might be necessary. Again, as everyone will appreciate and will be aware of, the ACAS Code of Practice will need to be followed in relation to any grievances that are heard. So it's important to take the process slowly and step by step. An important point also is not to attempt to conflate any issues if there are two conflicting belief systems that are raised by employees. So hear each complaint separately and give the individuals the full opportunity to raise their issues and fully explain their concerns. Moving on to investigations, and ahead of, for example, the HR team starting any grievance investigations, consider providing a briefing or a form of wider training about the stance that should be taken throughout. So what this means in practice is that staff who are investigating the complaints should take a neutral position to the extent possible, and they should always be mindful to remain respectful and balanced, irrespective of whatever their own personal views, belief systems, religion, or mindset might be. Staff should be encouraged not to impose any personal view on what is being raised by the employee who's raising the concern. Instead, at this stage, emphasis should be placed on listening without judgment ahead of the investigation findings. It's also important to make sure that HR staff are aware not to interrupt or otherwise make any comments or jokes that might be well-meaning, but might actually have the effect of alienating the employee. So behaviors like rolling of the eyes or using fairly inflammatory words such as dinosaur or woke should not be used, and staff should be warned against using them. The person conducting the investigation should also try as much as possible to operate from a blank canvas perspective, essentially, as I mentioned, going into listening mode and being open to the views that are being expressed and listening to those views. HR staff should go into an investigation also knowing all of the relevant information that's necessary. For instance, has the person specified a particular use of pronoun? Are there any other areas of specific sensitivity that may be relevant? In this respect, HR records referring to the employee's correct name, for example, rather than a reference to a previous name, for instance, pre-transition, is quite helpful. And you might want to also consider whether the HR advisor has an awareness of current terminology and terms that are now considered quite outdated. In any event, it can always be helpful to ask the employees of their own preference of the pronouns if there is any doubt. Next slide, please. We know from the first few sections of this webinar that the legal framework on conflicting belief systems is ever evolving and, as Lucy mentioned, highly fact specific. So when looking at the reality of attempting to consider conflicting grievances and conflicting grievance findings and outcomes, one of the first practical steps is to consider if there is any guidance available from the existing fact pattern. If we take a working example very briefly, so an individual raises a written grievance that confirms her own view that gender is binary and immutable in line with her Christian faith and requests that she accesses single-sex spaces, specifically the ladies' toilets, without another member of staff who is a trans woman coming into that space. At the same time, the trans woman has complained of exclusion, unfair treatment by the individual, and feels humiliated at the suggestion of using male toilets. Where do you start as an employer? So over the years, there have been several sets of guidance published to help employers navigate this landscape in relation specifically to single-sex access to particular spaces. However, unhelpfully, a lot of this guidance has now been withdrawn. So for example, in April 2024, the Government Equalities Office, the GEO, withdrew its guidance. Similarly, a guide for employers published by ACAS on gender reassignment discrimination in 2017 has been withdrawn. The CIPD guidance in this area has also been removed from the public domain, but it is still available to members. This means that, quite unhelpfully, there isn't current best practice so far that is easily accessible. But it's helpful if we can go back to the statute, and in this instance, the Workplace Health and Safety Welfare Regulations 1992 Section 20 says, suitable and sufficient sanitary conveniences shall be provided at readily accessible places, and sanitary conveniences shall not be suitable unless separate rooms containing conveniences are provided for men and women, except where, and so far as each convenience is in a separate room, the door of which is capable of being secured from the inside. Current ACAS guidance on toilets and changing facilities in this area is also helpful. So the ACAS guidance, for example, says that at some point during their transition, an employee will probably want to change the facilities they use. It goes on to say that if an employee tells you they want to use different facilities, it's helpful for employers to talk to these employees about when, for example, the change could happen, what, if anything, the employee wants to tell other employees, and usually asking employees in this kind of space and in this kind of scenario is one of the best starting points. ACAS further notes that everyone at work should be able to use facilities they feel comfortable with, and making a transgender employee use facilities they're not comfortable with could be discrimination. So the important point to take from here is that communication with the employee concerned on what that employee feels comfortable with is crucial. ACAS also says that if other employees raise concerns related to facilities, employers should be sensitive to these and take these concerns into account. And employers should consider the concerns and look for practical solutions that hopefully everyone can accept. ACAS provides some good solutions, and these include having one or more self-contained toilets that anyone can use, and making sure changing rooms have lockable cubicles. A practical reconciliatory outcome, therefore, is likely to be welcomed by all employees. And if we take into account ACAS guidance and as a more general approach, as I mentioned in the working example, in this specific scenario, a gender-neutral toilet with an entirely self-contained unit might be a good practical outcome. Turning now to thinking briefly about overlapping grievances and disciplinary cases. As most, or maybe everyone on the call will be aware, as set out in the ACAS Code of Practice on disciplinary grievance procedures, where an employee raises a grievance during a disciplinary process, the disciplinary process can be temporarily suspended to deal with the grievance. But where the grievance and the disciplinary cases are related, it may be appropriate to deal with both of the issues concurrently. That said, it really is important to keep following each stage of the process as opposed to missing out steps, which might be tempting, and jumping forward to a disciplinary sanction before all of the process is completed. And as mentioned at the start, it really is important, as I said, that the processes as stated in the hopefully updated policies are followed. Next slide, please. So what do we advise in terms of best practice to avoid disputes arising, and also the alternatives to escalation that Marion mentioned at the start? The first and perhaps obvious but critical point is that employers should instill a culture of dignity and respect. Although respectful debate is an inevitable and normal part of life, this doesn't mean that employers should allow unrestricted speech at work. Again, an obvious point, but all employees should be treated with dignity and respect, and employers should not tolerate discriminatory behavior in the workplace. But sometimes employers, and staff do have to tolerate views that they don't necessarily agree with. Employers have a responsibility to provide a safe working environment for everyone, and there is therefore this need to find a balance across differing needs and conflicting beliefs and views within an organization to ensure an inclusive workplace culture. In this respect, effective and up-to-date workplace policies and procedures can be really helpful, as well as staff training, which can also be very helpful for employers. For example, an employer can, in its policies, expressly recognize that individuals may hold conflicting beliefs, but confirm that there is still an expectation for employees to comply with and exhibit certain baseline behaviors of mutual respect. Secondly, training, and specifically training for managers on recognizing and resolving conflict. So managers should be trained in how to respond and resolve conflict in the workplace, and the CIPD report is quite helpful in this respect. The report found that managers are, unsurprisingly, at the forefront of both identifying and managing conflict, and also, perhaps unsurprisingly, can sometimes be the cause of it. For this reason, employers should provide appropriate training to managers so that they have the skill set and the capability to deal with conflicts at an early stage. Thirdly, consider communal spaces, facilities, and services. So, as I mentioned in the previous slides in relation to the use of restroom facilities, employers should ensure that all employees have access to facilities and services that they feel comfortable with and safe in. This might mean, in some cases, that employers have to revisit their bathroom or shower and changing room facilities. Next slide, please. So, alternatives to escalation. In terms of resolving conflicts that do arise, so it's really important to put in place a clear process for addressing conflicts that could arise from clashing views in the workplace. This will also help to ensure consistency of treatment and will also assist in guiding managers. So if there is a potential dispute between employees, then honest, open, and respectful discussions should take place. The discussions should really be aimed at improving the understanding by the employees of the impact that one person's views can have on others. It's often better to resolve disputes on an informal basis in this way without having to go through the formal grievance procedures. As Lucy mentioned, although and as also CIPD guidance sets out, although a zero tolerance approach is entirely appropriate in some cases, where, for example, the behaviors are extreme and clearly unacceptable or unlawful, this type of zero tolerance approach should not be used as a catch-all for every single scenario, because responding to every single scenario in this really punitive way can be unhelpful and unproductive. An employer should try and remain impartial if there are conflicting beliefs between different employees, although, as Marion mentioned earlier on, there shouldn't be a focus on a hierarchy of placing one particular protected characteristic over another. So it's important that employees' rights to hold their own views are not challenged. So attempts shouldn't be made to try and change the individual's views or ask them to justify it. Instead, the clear emphasis should be made on the potential impact of their views and the impact of those views on others. Employers should also make it clear to employees on what type of language or discussions are acceptable or not acceptable in the workplace. And again, in this sense, workplace policies and procedures and rules are even more important. Finally, it's really important to have some form of conflict resolution plan in place. Given the divisive political and economic changes and highly pressurized work environments that we are in, conflicts are likely to arise in the workplace, and often having a conflict resolution plan in place can help. Again, the CIPD guidance is clear and advises that employers do need to take a wider, more realistic understanding of conflict to recognize it and respond to it effectively. So although it might be tempting, conflict resolution shouldn't really be viewed through this narrow compliance lens of formal complaints, formal procedures, but conflict should be viewed as a likely part of the employment relationship and also navigating the workplace. Not viewing conflicts from this wider standpoint can lead to conflicts being dealt with in a reactive, ad hoc, and unhelpful way that can have potentially costly implications, which employers will obviously want to avoid. So the focus should really be on developing a wider organizational approach that develops early ways to resolve and prevent conflict rather than allowing conflict to be dealt with in ad hoc ways when they do arise. So with that, I'll hand back now to Marion. Thank you.
Thank you, Nella, and thank you, Lucy. We have got time for a few questions, and some have been coming in. I'll give Nella a chance to get a glass of water, but Lucy, I think there's one, if you wouldn't mind, I might direct this to you. One of the questions is, should employers be taking a more proactive approach? Because your case, I was thinking, was obviously around a social media platform, wasn't it, used sort of outside of work? But the question is, in terms of employee use and misuse of internal messaging platforms when discussing, in particular, non-work related contentious topics, and are there any steps that employers could take in terms of, I suppose, use of employer messaging facilities and things like that?
Yes, I think that there's a couple of things that employers could think about in this area. So one is training, and I think as part of that training, just making clear to employees that the rules around harassment and bullying and being respectful towards other people and considering other people's feelings don't just go away when you're using Teams or another kind of electronic messaging system. So those rules apply when you're using those systems as well. And that may sound obvious, but I have had experience of advising on cases where employees have been messaging on those types of systems, and I think perhaps losing sight of what they're saying because of the way in which they're doing it, and those messages sometimes make for quite shocking reading. And so one kind of guideline that employers could give employees is imagine someone else reading this and how this might look written down. And I think another point is around considering your relationship with another employee, and how, even if you're friends with someone and you feel that what you're saying is kind of being taken as jokey or banter, how that can tip over into something different, and that you should be kind of mindful of that risk as kind of viewed against the bullying and harassment and equal opportunities policy. And I think kind of making that clear to employees in training and in any written policy around use of firm systems, I think is a really sensible step. Where I think it does get really difficult and where a lot of employers struggle, I think, is where employees who are kind of friends outside of work are perhaps messaging each other on WhatsApp, and they may be doing that outside of working hours, and they may think, oh, this has nothing to do with work. But in a sense, if you're colleagues, and particularly if you're kind of colleagues in the same team, and especially if there's a sort of power imbalance between you, then that could well kind of tip over into some of your workplace interactions, and could even sometimes come within the scope of the sort of bullying and harassment policy. And I think that's something that employees often don't realise, and so probably something to be thought about as to how that's built into training and policy work in this area.
Yeah, I agree. Some of that ties in with what Nella's just talked about, doesn't it, in terms of training in particular for managers, but you're right, even IT sort of acceptable use policies, anything about employer provided tools and kit is probably a good place to set some, if you haven't done it already, some expectations around good behaviour and conduct. There's another question which is probably goes to a little bit about what I said at the beginning. Someone's asked, given the recent developments in the US, particularly in the DE&I space, do you actually think that those developments in the US are likely to permeate in the UK, and have you experienced any impact already? And I think I'd say yes, I have. I was at a roundtable last week where we heard people from a range of organisations, but particularly those who had US headquarters, and this was within the financial services sector, talking very clearly and explicitly about how programmes are being dialed back and how it's having an impact in the UK. And you might even have seen, I think it was yesterday or earlier this week, in fact, my former firm has come out in the UK as distancing itself from its US partner group, I guess, within the Big Four Association, to say the UK will still be pursuing its DE&I objectives, but I guess some of this depends on the power of an employer within its group structure. But we've also heard some very worrying stories about employees being genuinely concerned about what this dial back and pushback means. I guess particularly from those in minority groups who may feel that, they may already feel that not actually enough effort was being made to support and integrate them and include them in workplaces, but they will be genuinely worried now. And we've heard some concerns from those who lead DE&I initiatives, because fundamentally the aims of the organisation haven't changed. And of course, for all the reasons I touched on at the top of this call, the UK legal framework has not changed. So all the things we've just been talking about, inappropriate conduct, people expressing views, harassing others, views that could amount to discrimination of others, are still capable of sanction, obviously by an employer using the processes that Nella's talked about, but also ultimately by our tribunals and our courts. So I think that's another point to bear in mind. I've had another question, Nella. I think you've probably touched on this a little bit, but it is about the steps that employers can take to prevent these kinds of behaviours and disagreements arising in the first place. Have we seen any examples of employers taking steps to combat that, and how do you mitigate it if it does happen? I don't know if you've got any additional thoughts on that you'd like to share.
Yes, I think really it goes to the point that I made earlier, in that it's really important to have these adequate procedures and updated policies in place, and importantly as well that they're communicated appropriately to employees and those who are responsible, like HR professionals, so that everybody understands what type of behavior is expected of them and what will not be tolerated in the workplace. A lot of employers have benefited from updating their policies in this respect and making it crystal clear. Sometimes it's helpful in the policies to include examples. And in terms of your other point about mitigating the impact if prevention doesn't end up working, then again, it goes back to my earlier point of having really clear procedures, those procedures being communicated adequately and appropriately, so that not only are they handled effectively, but it's also clear to the organization how they will be handled. And again, as I mentioned, as tempting as it might be, it's really important to keep at the forefront that you cannot circumvent the procedures that are in place. So I would just echo all of the points that I made previously.
Thank you. And I think you also made the point that some of this is almost inevitable in the workplace. Human beings, who they are and what we all are, it's somewhat inevitable that we'll disagree. But I think again that chimes with something that Lucy said about the Higgs case, which is and on some of those zero tolerance examples you gave, Lucy. Similarly, knee-jerk reaction to that isn't appropriate either. And I think the sort of impression, wasn't it, in if I could just turn to you on the Higgs case, was that dismissal was a disproportionate sanction, and the court may not be alone in thinking that. I'm sure there's others of us who might have thought that a word, a chat, a discussion about how others perceive that kind of language and how those kind of things might be received might be at least a first start, even if subsequently disciplinary action might be necessary. I don't know what you think about that, but I think a more nuanced approach is generally what we're calling for here, I think, isn't it?
Yeah, I agree. And because the Higgs case wasn't sort of looking at the unfair dismissal aspect, or at least not at that level, it perhaps didn't shed as much light on that point as it otherwise would have done. And I think that what the court's sort of saying in between the lines is that action short of dismissal might have been appropriate, but didn't kind of opine on that because it's not relevant to the legal test. And that's where I think it gets a bit dangerous, because I think because the other sanctions weren't talked about, I think you could look at that case and think that the court was saying that what Mrs. Higgs did was entirely okay and she was beyond reproach, which actually isn't what they're saying at all. But I think it's important to, I think the nuance point is a really good one, and one that kind of permeates the Higgs case, but also the zero tolerance cases that that we were talking about, and I think just kind of drives home the point that sort of careful judgment is needed in all of these cases.
Yeah, I agree. And I think that goes to your point about we should be really clear. None of this case law gives anybody carte blanche to behave in a way that, you know, might amount to hit those thresholds of inappropriate conduct. It's and then it's about how you manage it as an employer internally. Probably got time for one more, which I don't mind picking up, because it's about the financial services sector. And somebody's asked, are we expecting the regulators to use case law to make decisions? And for those in the sector, you'll know that we are still waiting for some very specific guidance from the FCA around how they view this sort of behaviour. So not stuff that seems inherently within their wheelhouse, but the broader stuff around culture and conduct and discrimination and harassment. And I think to answer that question, I'm really sorry to that person. We're going to have to watch this space, aren't we? Because we are still waiting for the guidance. We thought what the FCA would be coming out with might be quite prescriptive, but recent press comment they've made suggests they might be moving to a slightly more sort of outcomes-based approach to this, because they're mindful of the government's drive to increase growth and general sort of economic activity. And I think they've had a little bit of a warning about not tying employers up with too much red tape. So we really need to see. But you're absolutely right to pick up on the concern that their original proposals raised, which is how an employer in the financial services sector in particular is expected to police, and indeed even in the first place know about how somebody behaves outside of work when it hasn't already been brought to their attention via other means. So that kind of outside work conduct the regulators suggested could be relevant to things like fitness and propriety tests, which are sort of regulatory standards that individuals have to meet. So it is a concern, we know, for HR in that space. And as soon as we hear any more, for anyone who's listening, we will update. So I think that probably brings us very much to the end of this session. We would like to ask a couple of survey questions, if I can get those up on the screen. We always love hearing your feedback, and we always really are genuinely interested to know whether these sorts of topics, it's obviously useful to hear about them, we hope, in this kind of format, but it's sometimes helpful to have a bit more of a drill down. And so there's a couple of poll questions here, which is specifically thinking about the content today. Are these the kind of things where you think it might be useful to have some training in your workplace? Is this the sort of thing that you'd actually welcome the opportunity to discuss round a table, Chatham House rules, and possibly even with peers in your sector, particularly if you're a regulated sector? You might find that kind of thing helpful. So please, just before you log off, if you could have a go on that poll for us. The results won't come up visibly now, so nobody will see how you vote, but it will be super useful for us. As I said, we have recorded this session, and we will disseminate a recording of the session and all other relevant materials. I think we've nearly answered all of the questions, but I'll just double check before we send that out. And we will also be asking you just a few more questions, if you wouldn't mind helping us make sure that we make these sessions and future sessions as useful to you as possible. So if there are issues that you would very much like us to discuss, whether in again a webinar format or a roundtable one, please do let us know. And otherwise, if there's anything again today that's triggered your interest, or you're dealing with and you're a bit worried about, please do reach out to any of us or any of your normal Fox Williams employment team. And we very much hope to see you another time. And in the meantime, we will, of course, keep you up to date on any developments on any of the things we've talked about today. So thank you very much for joining, and have a good afternoon.